Hi everyone, I'm attorney Poonam Minhas. I practice U.S. immigration law all over the United States. So today I wanted to talk about something a little different in a similar category that I've done in the past, which is parents of U.S. citizens who are seeking adjustment of status in the United States. And those U.S. citizens are 21 years or older. Now, these circumstances that I want to discuss actually came about during consultations that I've had, and they were very alarming. So I wanted to share it with you. So make sure to stick back and also watch certain sample interview questions that might be asked if you and your parent has been scheduled for an adjustment of status interview, and some tips that might be helpful for your case if you are seeking to file for your parent, or you're a parent yourself and you're seeking to file for your case, what's really important and what you should look out for. So one circumstance that came to my attention was children who are filing for their parents and only end up filing the I-130 petition and not the adjustment of status application. So typically what happens is U.S. citizens who are petitioning for their parents when they're eligible for the green card are only filing the main petition, which is the family-based petition, but not filing the adjustment of status. And once the I-130 petition comes back approved, they're kind of just thinking, you know what, the green card is going to be mailed to us. But that's not how it works. And that was very alarming and concerning to see, because even if you look at the I-130 application, it asks you, where is the beneficiary trying to seek their adjustment or do their process? Now, typically, there's two processes. One is adjustment of status in the United States or consular processing overseas. Now, that has to be indicated on the I-130 petition. Usually, if someone makes a mistake, sometimes they hold the petition after it's approved with USCIS in the United States, or they'll send it over to the National Visa Center. So what's alarming is that just having an approved I-130 petition doesn't give you the path to the green card. You also have to adjust under a separate petition. So that's very important. And one other thing I wanted to add is even certain individuals who are filing for their parents, they have the pending concurrent filing of the family-based petition and the adjustment of status. They filed for them to get their advanced parole travel document. Everything looks good. And then lo and behold, under the current administration, they are getting a notice to appear. And then you're wondering, wait a second, why did they get a notice to appear if my parents' case is pending and they have their adjustment of status with immigration and we got the receipt notices and we did the biometrics and everything is all great? What happens is typically when their time on the I-94 expires, it doesn't put them in a lawful status. They just have a pending adjustment of status application, and that just gives them authorized stay. So it gets a little tricky, and some individuals, unfortunately, the beneficiaries are getting notices to appear, and that is requiring them to appear before a judge in removal proceedings, or they're also known as deportation proceedings. And if you're in that situation, then I highly recommend you contact an experienced immigration attorney to talk about your case and what can be done about it. Another situation I came across was children who are ready to file the I-130 and adjustment of status application, and then they don't have the finances to file the affidavit of support. Be very, very careful, because if you're now ready to file everything, but now you're like, okay, I don't have the finances to support them because I'm a student, or I don't really have, a great job. I'm only making maybe like $15,000 a year, and that's not going to cover what immigration is looking for to sponsor my parents. That is going to most likely and probably lead to a request for evidence or a straight denial. You want to be very, very careful if you have the packet ready, but also look for a co-sponsor, someone who may be able to assist financially for your parent if you can't do that. So work with an immigration attorney if needed and see What's the proper paperwork? What do you need for the affidavit of support? Look at the household size. These are things that should definitely be discussed, and have a game plan. Have something planned before you are actually filing something with immigration. And you want to make sure you have everything so you can avoid the RFE or getting a straight denial. And then remember, right now under this administration, it's highly possible to be receiving a notice to appear. So if the case is denied, then the beneficiary, aka your parent, may receive a notice to appear in court. So be very, very careful. Again, that's when I highly recommend you retain or speak to an experienced immigration attorney who knows what they're doing. Okay, so the next thing I want to talk about is the difference between what the family-based petition is and then what the adjustment of status does. So the family-based petition, where you're pretty much telling immigration, all right, this is my mom, this is my dad, and I can prove this because, and then obviously you give the identity documents, and eventually later, sometimes they need a DNA test. But you're pretty much proving, look, the relationship between me and my parent is legitimate, it's bona fide, and please approve our petition so then we could seek the green card. So that's what you're primarily trying to do under the family petition. When you get to the adjustment part, right, that's where you really have to see, okay, whether your parent is eligible to not only file the adjustment of status application, but also get the green card in the US by not having any issues. But what type of issues would that be? Maybe there's allegations of fraud or misrepresentation. Maybe at the time that they applied for the visa, they may have lied on their application or testified in front of the officer or provided a fraudulent document. Things like that could come up. So that is important to look into. Maybe there are issues of alien smuggling. Maybe they helped someone financially or physically come into the United States. There could be issues with their arrests. There could be issues with whether they had a previous deportation order or they're currently in removal proceedings, and jurisdiction might not be with USCIS. It's maybe they have to adjust before the court. These are things that are very, very important and that need to be looked into. Also, what if they are not lawfully in the United States, like they didn't come in on a visa? Now that gets a little more complicated, and maybe at that stage, only the family-based petition could be filed. And I know that's a little off topic, but at that stage, it's like, okay, well, do they even qualify for a waiver? Do they have a qualifying relative for that waiver? And if they do, then maybe eventually they could return back to their home country for the rest of the processing. But adjusting a status, you want to also see whether there are any hurdles that may stop them from getting that green card, or maybe they need to file a fraud waiver if it gets to that point. So that is definitely something that if you feel there is a red flag or there is some type of concern, that's where you pick up the phone, you schedule a consultation with an experienced immigration attorney and talk to them about it. Before I jump into the sample interview questions that may be asked during you and your parents' interview process for the adjustment of status, I do want to mention that under the Trump administration, it is possible to receive your green card without an interview. It is still possible. I've gotten some where my clients did not have to go to the interview and it was waived and they were able to successfully get the green card. So yes, it is still possible to get that done under the Trump administration. So please don't lose hope, and definitely work with someone who you trust, who can help you navigate through your case if you have any difficulties or have any questions. But yes, it's still possible. So stay tuned and make sure to catch some sample interview questions that may be helpful if you do have an interview. I've gathered some questions based on my own experience and from some of my colleagues who recently went on parent adjustment of status interviews. And I wanted to share some samples, and not all interviewing officers are going to ask the same questions. Each case is different. Your circumstances are different. So it really varies. And maybe you might hear some questions that I talk about today, maybe not. Maybe there might be other questions that may be asked if you are going in for your interviewing process. So a couple of things I might ask is, when was your child born? And how did your child become a US citizen? Or things like, were you ever denied a visa in the past? Or have you ever had your visa revoked? Have you ever lied to an immigration officer or any other law enforcement officer? Have you ever given the government any fraudulent document? When you came into the United States, what visa did you enter with? And what was the purpose of your visit at the time? What type of conversation did you have with the CBP officer at the airport? Did you have a return ticket at that time? What was your intention at that time when you came into the United States? Have you ever helped anyone come into the United States, whether it was physical, whether it was by giving them money? So financially, did you help someone come to the United States? Have you ever lied on your visa application when you were applying to come to the United States? Has anyone ever filed an application for you in the past for a green card? Have you ever abandoned your green card? Has your green card ever been rescinded if you had one in the past? Have you ever been to the United States before? If yes, did you cross the border or did you have a visa? And then what happened? Have you ever overstayed on a previously issued visa? How did you come into the country recently? Have you ever traveled outside of the United States without authorization? Have you ever worked without authorization? Have you ever filed for any type of relief to protect you from deportation in the past? Are you in removal proceedings now? Tell me a little bit about your asylum claim that is pending right now, that you filed in 2006. So you see where I'm going with this? USCIS wants to make sure that you are telling the truth. They are trying to see if your relationship with your parent or your child is legitimate and valid, and that whether your parent is actually eligible for the adjustment of status. And if there is a hurdle, whether they are eligible to file for a waiver, and then that might delay the process, but at least if they are eligible and they file and the waiver is successful, then they may be able to receive their green card and then not have to worry about that issue. Because potentially later in the future, because I like to think about the bigger picture, is that you don't want to have them go through a harder process when they're trying to file for US citizenship later down the line. But of course, that is a worry for later. But at the same time, I've also come across individuals who have received a green card in the past, wait the 5 years or 3 year statutory period, depending on whatever statutory period they're applying under. And when they go to the citizenship stage, USCIS goes, hold up, how did you get your green card? Because we have XYZ to show that you engaged in fraud and there was never a waiver filed, so we should have never gave you this green card. Now it's like denied citizenship. And now what do? They're pretty much saying, you know what, we should have never gave you this green card to begin with. And that's where you want to make sure you speak to an experienced immigration attorney to ensure that you may not have these type of problems later down the line. Because you want to make sure you got the green card the right way. And things happen, and I understand that. But when you're at the stage where you know you're about to apply for something and you're unsure because there might be a red flag or certain situations you're unsure about, this is where you need to speak to someone, because now the rules, the regulations, the policies, the law, the statute, that all comes into play. That's always been in play. But I know for a fact that many times people are like, oh, these are just applications and we meet the 1, 2, 3 requirements and we could just file. We're good. We're golden. And sometimes that might be true, but sometimes that might not be. So be careful. And, last thing I want to say to all of you is that, look, if you haven't subscribed, please subscribe and hit that bell icon to stay updated on anything I post on U.S. immigration law, whether it's based on any experiences, consultations, general matters, updates in policies, regulations, anything that has come out through USCIS, Department of Homeland Security, or even from the White House itself. It would be best to hit that notification icon and also subscribe so you could stay tuned and keep watching for updates, and it might be helpful not only for you, but someone you might know. So thank you so much. Hit that like button if you enjoyed today's topic, and I will see you soon.